Hey tipsters! In today's video, I'm going to walk you through section by section on the exact mortgage and promissory note that I use in my land flipping business to structure private money. I actually wrote an entire article for the RE Tipster blog that goes into a lot of detail on everything related to leveraging other people's money as a real estate investor, and ultimately why for my business, I choose to bring on private money investors as lenders instead of partners. If you want the full scoop on that, I would definitely check out that article. At a high level though, having private money investors come in as lenders allows them to have the security of being a first position lien holder while allowing me as the operator the most amount of control over the property. As with everything in life, there are definitely some pros and cons to this approach, but all things being equal, it's my opinion that this is one of the better ways to structure private money as a real estate investor. Before we go any further in this video, I need to throw out a major disclaimer. I'm not an attorney or a CPA, and I am definitely by no means giving any kind of legal or financial advice here. All I'm doing here is showing you what I'm currently doing in my land business. If you want to do something similar in yours, I would highly suggest that you speak to your legal and financial advisors to make sure that everything is set up with your best interests at heart and in accordance to the best practices for your market. Now, to lay some groundwork, let me briefly go over how I structure the lending program for my business at a high level. When a private money lender agrees to fund a deal for me, I have them pay for both the acquisition costs and the closing costs. So they put up the money that's owed to the seller and to the title company or closing attorney who facilitates the transaction. I cover the cost of direct mail, process leads, and get properties sold. They simply wire in funds. If we end up selling a property within 3 months or less, I pay them out interest equivalent to 25% of the profit after we paid closing costs, agent commissions, and we've reimbursed them for their principal from when we initially purchased the property. The remaining 75% of the profit goes to me as the land investor. If we end up selling the property within 3 to 6 months, we then bump up the interest to make it equivalent to 35% of the profit under the same conditions. If we end up selling the property within 6 to 12 months, we then bump it up to a 50-50 split, or paying the lender interest equivalent to 50%, leaving 50% for me as the land investor. At the 12-month mark, the lender has the option to call the note due, meaning I have to pay them back their principal, and the way that we've arranged it, we also give them 10 to 12% interest just so that they get some kind of ROI for their investment. Now, I want to be clear, the lender can stay in the deal if they want to, but if they don't, at 12 months, they can get their money back plus some interest for their trouble. Now, in the event that we've reached the 12-month mark and the lender decides not to call the note due, but instead chooses to stay in the deal, the profit split would become negotiable at that point. As the operator in my business, I would obviously prefer to keep it at a 50-50 split, but if I had a lender who was willing to stay in the deal, but only on the condition that they got a higher percentage of the profit, I would definitely be open to it depending on the circumstances, especially if my alternative would be paying them in full with additional interest. It really would depend on the circumstances though. I'm far less likely to budge on the 50-50 split if the delay of the sale was due to some sort of process that ultimately increased the value of the property, like rezoning it or subdividing it, gaining easement access, and so on. But if the delay was simply the result of poor underwriting or some sort of error on my part, I would be extremely motivated to make my lender as happy and as comfortable as possible, even if I ended up not making any money on the deal. Under these circumstances where we haven't sold a property in 12 months because of a mistake or error on my end, my goal would be to keep the lender open to working with me in the future. So I'd be pretty keen on giving them anything that they wanted at this point within reason. I'd have to prove that this lender could continue to trust me. So I do all I could to make it right by them. To wrap this up, the last thing worth mentioning is that I don't pay any payments whatsoever until either the property sells or the lender decides to call the note due. So now that you have a working knowledge of how my lender program works, let's go ahead and go section by section here on this template. Now, the first thing that I want to go over with you is I want to cover the things that I have highlighted in yellow. Whenever I create a template that I'm going to be using over and over again in my business, I always highlight the portions of the document that need to be updated with each new property we acquire. That way, I never miss anything and never make a mistake. I would highly recommend this practice on not only these documents, but any other type of template that you use over and over again as a real estate investor, because to be honest, it's been a game changer and has made my life so much easier. Now, something to be aware of, I technically have two different templates. I have the mortgage and the promissory note saved in one document here in this video. I'm going to present both documents in a series where we have a part 1 and a part 2. And in part 1, which is this video, we're going to be covering the mortgage and security agreement. And then in part 2, we'll go into detail on the promissory note. Now, you might be asking, what's the difference between a mortgage and a promissory note? Put very simply, a mortgage is a type of loan that's secured by real property, and a promissory note is the written agreement that outlines the terms, conditions, and details of that mortgage. So to reiterate, the mortgage is a loan that is secured by real property, meaning it's tied to something real and physical that you can touch with your hand. If you stop making payments on the mortgage, the lender can recoup their investment by taking your property away from you, therefore making it a lot more secure for the lender. The promissory note outlines all the details of the mortgage, defining what's considered as a default, what happens under certain conditions like a death or major injury, the order people get paid in, and so on and so forth. If you find it helpful, a promissory note is to a mortgage kind of what a purchase agreement is to a deed. The mortgage is the loan, just like the deed is the proof of ownership. The promissory note details all the conditions surrounding the loan, just like the purchase agreement details all the conditions surrounding a transfer of ownership, like the price, who pays the agent commission, who's going to cover the closing costs, who issues a tax credit, etc., etc. Starting off with the top section here, this is simply declaring what parties are involved in this agreement. The mortgager is the borrower, which in our case is you, the real estate investor. You'll want to put your name or the name of your company as well as your business address in the sections to the left and right of the word mortgager. The mortgagee is the lender funding the deal, and you're going to want to put their information to the left and to the right of where it says mortgagee. After that, here where it says grant of mortgage and description of premises, this is a further declaration of what this document is and that it's attached to a specific property in such and such county and state with such and such tax ID or APN number at such and such address. Now, if you're like me and you buy a lot of vacant land, it's common to run into a property without an address. So when that happens, what I do is simply put the street name, city, state, and zip without a house number in the appropriate section to the right of the words common address. One last thing to take note of here, you'll see that my template mentions successors, assignments, heirs, and personal representatives. This indicates that if something happens to the lender, like if God forbid they go into a coma or die or something, their interest in this agreement will transfer to their close relationships like a business partner or family member. Moving on to the section entitled indebtedness. This section defines all that's included in what's going to be owed back to the lender. Starting off with A, this is the total amount of the loan, which in my business, like I said earlier, includes both the purchase price and the closing costs. So practically speaking, I'll wait to write up the mortgage and promissory note until I've received the exact amount that us as the quote-unquote buyer will need to bring to the closing table. I determine this amount by reviewing the settlement statement, which is kind of an overview of all of the fees and closing costs that are going to be involved in the transaction. It's also important to inform your title company or a closing attorney that you're going to have a private mortgage recorded on this property, because that has an impact on the total amount of closing costs. In the market that you're investing in, the county may charge a little bit more for recording a mortgage than the typical recording fees. Now, moving on here to section B, C, and D. These in short are a bunch of fancy words that say in effect, the borrower is legally obligated to pay back the lender all the money that they lend on this property, both now and in the event that the lender has to provide more funds in the future, and that the lender is to be paid the agreed upon interest and or additional compensation detailed in the accompanying promissory note. Say there's a situation where a property isn't selling because there's a bunch of trash and junk scattered throughout the property, or because the grass is so high and so thick that no prospective buyer can actually walk through it. In a situation like this, the money person involved in the deal may consider putting up capital in order to take care of the issues at hand in order to get the property sold. This section of the agreement is saying that if the lender ever puts up additional money beyond the initial principal amount, the borrower will have to pay them back on every dollar that they bring to the deal. And the way that this contract reads includes attorney fees, which, if I understand correctly, implies that if things were to go south and they had to sue you in order to recoup their investment, you may have to cover their attorney fees as well. So to recap, this section states that the borrower is obligated to pay back the initial principal amount of the loan, any additional costs related to the property beyond the initial principal amount, and any interest or additional compensation outlined in the promissory note accompanying this mortgage. The next section here states that the borrower ensures that the following statements are true. A, that the property is free and clear. B, outside of this mortgage, there are no other loans on this property or any other binding agreements to any other party. C, everything the borrower is saying about the deal and property is the truth and they're not hiding anything. D, that the borrower is abiding by the law. And E, that nothing can be changed about this mortgage agreement except by the written consent of the lender. Underneath where it says the word payment, this is self-explanatory. It's just stating that the borrower will pay back everything owed to the lender when it becomes due. Under taxes, this section states that the borrower is responsible for any charges that could become a lien against the property if left unpaid. Things like HOA dues, property taxes, and so on. Now, again, all of this is negotiable and customizable. You could adjust this so that the lender is responsible for these items, but in my business, I decided that I'd be the one to handle it. For one, outside of dealing with taxes or HOA dues in escrow when we buy or sell a property, I rarely end up paying for items like these out of pocket because of how quickly we move inventory. Sure, it can take a few months to get a property sold, so it ultimately depends on when we buy the property in relation to the date property taxes or HOA fees are due, but more often than not, I don't end up having to pay them. When we cover items like these in escrow, either by proration, bringing them current like if there was back taxes or something, or by paying them in full, these items are just a part of the overall closing cost. So the lender ends up paying for them kind of in a roundabout way. Secondly, in the event that we do end up needing to pay for items like these out of pocket, since my company is on title, I'm the one that's getting the tax or HOA bills. So logistically, it's just easier if I handle it. Moving along to maintenance of security. Here, the borrower is agreeing to keep the property clean and in good condition. So if there's any amount of maintenance like lawn mowing or picking up trash or what have you, it's the borrower's job to handle it and get it cleaned up. Additionally, this section is saying that the borrower will uphold any standards required by governmental authorities because nobody wants a compliance lien. Moving right along to performance by mortgager protective advances. Here, the agreement is pretty much saying, even though we've established that it's the responsibility of the borrower to take care of any charges that may result in a lien or judgment if left unpaid, the lender has the right to step in and get things handled in order to secure their interest in the deal. Interest being the lender's right or stake, quote unquote, in the property. And then this section reiterates what was said previously, that any money the lender puts into the deal must get paid back. And here, it even goes further and states that the lender can actually charge interest on top of the cost beyond the initial principal amount. Pretty intense, I know. This section then wraps up stating that if any additional cost beyond the initial amount occurs, the borrower must pay back the lender on demand, meaning whenever the lender wants to be paid. So essentially, they can call the note due. And these potential extra costs will be added as a lien against the property until paid. Next, under the section that says condemnation, this is essentially saying that if for whatever reason something happens to the property, like it's damaged or it's sold or it's taken away for some reason, like from the government. If there's ever a financial gain or loss from an event occurring, it's going to be applied to whatever's owed to the lender. So if it gets sold and there's a big surplus of revenue, that revenue is going to pay back what the lender is owed. And if there's a financial loss, you're still going to have to pay what's owed to the lender regardless. Moving right along to default. This is the part of the document that defines what a default is based on this agreement. A default is essentially an action from the borrower that violates the terms and conditions of the mortgage that they have in place with a lender. And it results in the termination of the agreement, making the total amount owed due immediately. So this section defines what specific actions are considered a default on the loan, with the first one here stating the obvious, that if the borrower does anything considered as a default or doesn't pay what the lender is owed on the agreed upon due date. The next one is pretty self-explanatory as well. It's saying that if the borrower doesn't do what is agreed upon in this mortgage agreement, it's considered a default. And then section C here is saying that if the borrower gets into any form of legal or financial trouble that forces the property to be sold or causes a lien to be placed on the property, then it's considered a default and the lender can make the total loan balance due immediately. Moving on to D, this is saying that in the event a borrower sells the property or gets another loan on it, it's considered as a default and the lender can make the total loan balance due immediately. Moving on now to remedies. This is where it actually says that in response to a default, the lender has the option to make everything that's owed to them due immediately. It goes on to say that in the event that the lender exercises this option, the borrower will give the lender the right to take control of the property so that they can try and sell it on their own in order to recoup the money that they put into the deal. Moving on now to invalidity. In layman's terms, this section essentially says that if for some reason a portion or a commitment within this agreement turns out to be invalid or legally unenforceable, it doesn't automatically invalidate the entire agreement. So if one little section of this agreement turns out to not be enforceable by law, everything else that is enforceable by law stays intact. Moving on down to expenses. This is just a reiteration of what's already been said previously. Any dollar that the lender spends beyond the initial principal amount of the loan in order to protect their interest must be paid back and causes the entire loan to be due immediately with additional interest charges at the highest lawful rate. Next, we have definitions. This section is more of a legalese disclaimer than anything else, so there's not really much for us to discuss here. I'm going to go ahead and move on. The notices section just defines what is acceptable as an official form of communication in regards to this agreement. So delivering something in person, by email, or by traditional snail mail is acceptable. Therefore, phone conversations, texts, and other forms of communication outside the scope of what's stated here is not acceptable and probably won't hold up in court. So be aware of that. Number 14, binding effect. This is similar to number 12, where it's more of a legalese disclaimer than anything else. It's pretty much just attaching this mortgage and the lender's interest in this deal to the physical property. So even if the borrower dies or becomes incapacitated or sells the property from underneath the lender without paying them, nobody's going to be able to escape this mortgage without giving the lender what is owed to them. Moving on from there, we have waiver of rights. If the borrower defaults under any circumstances, they automatically waive their rights to the property and give the lender total control of it so that they can do whatever they need to in order to sell the property and recoup their investment. Moving on to number 16, exhibit. This is simply saying that there's going to be an exhibit attached to this agreement. And what should go here in Exhibit A is the full legal description of the property. Now on this, make sure you're listing the full legal description and not the abbreviated one commonly found through websites like DataTree or Agent Pro 24/7. And finally, we've reached the end of the document. The last section is the effective date. And luckily, it's pretty straightforward. It's simply saying that the borrower commits to signing and delivering this mortgage agreement on the date specified within it. As we scroll down, you'll see the notary section where you're going to sign as the borrower and get it notarized by your local notary or bank or what have you. And then after that is simply the Exhibit A where you're going to put that full legal description. This officially concludes the video walkthrough of the mortgage template that I use in my real estate business. Now make sure you check out part 2 where we're going to cover the accompanying promissory note. See you there.